of contract. So we have lot of types of contracts. So let's just revise contract. What is a contract? As per section 2 subclause H, an agreement which is enforceable by law. So we can conclude the same as agreement plus enforceability of law makes a contract. Going forward with the types of contract. As per the formation or on creation, we have expressed, implied, quasi contract and e-contract. On the basis of validity, we have valid contract, voidable contract, illegal contract and enforceable contract. On the basis of performance or execution, we have two types, executed and executory contract. On the basis of liability, we have unilateral or bilateral contract. So on the basis of formation, first category is express contract. The terms of the contracts are expressly agreed upon from the side of the parties, either orally or in a written form at the time of formation of the contract. Like A wants to sell his watch to B and B agrees to buy that particular watch for rupees 2000. So A made an offer and B expressly accepted that offer and paid him rupees 2000. Next is an implied contract in which is inferred from the acts or conduct of the parties, or you can also judge it from the circumstances of a case, like ordering in a restaurant, boarding a public bus. Next one is quasi contract, that is created by law. It doesn't arise by virtue of any agreement, but the law enforces or recognizes these contracts under special circumstances. Even no intention of parties is there to enter into such contract. It is based on the principle that a person shall not be allowed to enrich himself at the expense of another. So let's take some further examples for it. As per section 68, claims for necessaries applied to an incapable person. Section 69, payment of interested person. Section 70, payment of non-gracious act. Section 71, liability of finder of goods. Section 72, payment of delivery by mistake or under coercion. Next is we have this e-contract. Now this e-contract, as the name suggests, is a internet contract. E-contract is one which is entered between the parties via internet. So the medium is what? The medium is internet. This is one of the most common ways of contract in current scenario these days. Offer and acceptance of the parties do not happen in person. All of the things happen but over the information highway or through a medium which is called internet. So there are three main methods: by email contract, or you can do it through online website contract. Online or click to agree contract is also one of the things. Like Amazon, this is what we are buying things from Amazon. So Amazon is having a website and through which we are contracting with it. You can see some kind of examples on your screen regarding e-contracts, how they are done. So this is user agreement. You just click on I agree and it is done. So you can also call it the click wrap agreement. Based on the validity we have is valid contract. An agreement which is enforceable by law is called a valid contract. That particular contract also has all the essential elements of a contract lined up under section 10. Both the parties to the contract can enforce that particular contract. Next one is voidable contract. This voidable contract is a contract which is accepted by law at the option of one of the party but not at the other. Entry into a contract by coercion. So now it depends on parties, either to continue that with that particular contract or to just rescind that particular contract. Next one we have is a void contract. So this particular void contract is a contract which ceases to be enforceable by law because it is void. When it ceases to be enforceable, a valid contract becomes a void contract under following circumstances: on the destruction of subject matter of that particular contract, contract becoming unlawful, death of the parties becoming unlawful. Next we have is illegal contract which are forbidden by law or which are declared illegal by law, or the law doesn't allow them, or they are prohibited by the law. An illegal agreement are void agreement, but all void agreements are not illegal. Unenforceable contract is good in substance, but because of some technical defect it can't be enforced by law. So now it depends on the technical part. Based on performance, we have executed contract. An executed contract is one in which both the parties have performed their respective obligation. Hussein agrees to paint a painting for Arjun for rupees 5,000. He paints the painting and Arjun pays rupees 5,000 to him. Next is executory contract. Contract in which one or both of the parties to the contract have still to perform their obligations in future. Partially performed or wholly unperformed is termed as executory contract. For example, if Hussein painted the painting, Arjun didn't pay rupees 5,000 yet. Next we have is on the basis of liability. First one is unilateral contract. A unilateral contract is one in which only one party has to perform its obligation at the time of the formation of the contract. The other party having fulfilled his obligation at the time of the contract or before the contracts come into existence. Like reward of $100 for the lost dog. Next category is bilateral contract. A bilateral contract is one in which the obligation is on both of the parties to the contract is outstanding at the time of the formation of the contract. Bilateral contracts are also known as contracts with executory consideration. They are somewhat similar to executory contract as well. Thank you.